So the first set of issues involve considerations for forming the employee-owned entity, and I'm sure many of you are familiar with the limited liability company form, cooperative, corporation. Each of them has a different underlying structure, might have its own set of tax considerations, employment considerations. The traditional corporation, any of these can be used for employee ownership, by the way. The traditional corporation is a highly rigid, somewhat inflexible structure. The corporate form is available in every state. Likewise, the limited liability company form is fairly standard, available in every state by now. That is on the opposite end of the spectrum from the corporation. It's highly flexible. It's a creature of contract, so the particulars of how an LLC is organized is set forth in an operating agreement. The public benefit corporation, how many of you are familiar with the public benefit corporation? Okay, so it's a variant of a traditional corporation. It's a separate statute that has been adopted in now about 37 states in the District of Columbia, most notably Delaware, the motherland of American corporate jurisprudence, has a public benefit corporation law. The public benefit corporation law is a corporation that embeds social and environmental mission protection in exchange for certain added responsibilities on the part of directors. Ultimately, it's what allows directors to consider the mission in parallel with and on balance with financial considerations. It solves for what's known as the fiduciary duty problem in the corporate form, which exposes directors to legal liability in the event they make a decision that doesn't maximize financial gain. The great example I heard yesterday is if a business is polluting a river and the fine is $100, but the fix is $10,000. In the traditional corporate form, the simplest sense, the directors would be legally liable for spending $10,000 to solve the problem. They would have to pay the fine. The public benefit corporation form allows them to embed environmental protection or considerations in their mission. They self-select what that public benefit purpose is, write it in their charter. That then becomes a lawful purpose for the corporation. The directors can balance financial considerations, could make a long-term decision, choose to pay $10,000, and would be legally insulated from a shareholder action. Question?
Just for those in Washington, it's known as a social purpose corporation.
Right. It's known by several different things. It's either public benefit corporation, benefit corporation. You said social purpose corporation. California has both a social purpose corporation or a flexible purpose corporation and a public benefit corporation. It depends where you are.
So my question would be, are there examples that you can give that show articles of incorporation for that type of?
Yeah, so I don't know if it's the case in Washington, but in many states, the articles of incorporation for every entity is available online. So you could find any public benefit corporation and look at their articles.
You could just look it up by those terms somewhere?
I don't know how the registry, the Secretary of State's website works here. Can you search?
In Washington, if you just plug in under their search engine, SPC for Social Purpose Corporation, you'll get anybody who's a...
Because that has to be in the name of the company?
Yes, it must be in the name.
Okay.
So what you'll find then is you'll look for the purpose statement or the article that spells out the corporate purpose. That must contain a statement of public benefit. Another, Diane?
So most of the types of businesses have a form at the Secretary of State. Unfortunately, for our cooperative statutes, we do not have a cooperative form. And you just need to know what those statutes are, and I know that you're going to reference them.
Mm-hmm.
And
So you
follow
can't
the
just
rules.
like search it for cooperatives?
Not for a form.
Yeah, lots of states will just make it simple, and you can fill out an online form or a template form to file articles for a corporation or articles of organization for an LLC. And what Diane is saying is in Washington, there is no template form to file articles of incorporation for a cooperative.
I believe they do have them for some statutes, but you do have to
Not for
request
the,
them
not for the cooperative.
for the cooperative statute.
Which one?
I think it's 2378. Not on mine, no.
Okay, well, we'll reference the Washington statutes here in a minute. We'd be remiss not to mention the Perpetual Purpose Trust. This is kind of a shiny new object in the social enterprise world. It's a model that allows the purpose of the business entity to be protected by putting the shares of that business entity in a Perpetual Purpose Trust. The Perpetual Purpose Trust, led by a trustee, then votes those shares with the mandate to carry out that purpose. It's both complicated and it's only available. The combination of perpetuity and purpose trust is only available in 6 states. But we mention it because it is a form for employee ownership. There is in California, California Harvesters is a company. I think it's a public benefit corporation, which is owned entirely by a perpetual purpose trust. The perpetual purpose of that trust, say that 5 times fast, is to benefit the workers. The workers are not the designated individual beneficiaries of the trust. It's just their benefit is the purpose. And so for perpetuity, that co-op or that entity will benefit the California harvest workers.
So other considerations in talking and choosing an entity for your conversion into an employee-owned company are state entity options. Colorado has some really excellent co-op laws, and we are coined the term that Colorado is the Delaware of co-op law. But it turns out that Washington just passed a new LCA statute, a limited cooperative association statute, so they're going to be on a par with statutes in other states. But if you're working with out-of-state entities, then you need to look at their particular statutes. For example, in Arizona and other states, you cannot form a worker co-op. You can form an agricultural co-op, or if you want to have a utility, electric utility, but you can't form a worker co-op. So state entity options are very important. Your tax implications. There are so many different ways to tax a co-op. You can tax it as a partnership, you can tax it as a corporation, and you can tax it as a part of the Internal Revenue Code called a Subchapter T corporation. And we'll be going into that in more detail. What are the financing needs of the entity? How is the conversion going to be financed? Who's going to pay what, where, when? Do the employees pay for the buyout? Does the owner pay for the buyout? Outside lenders, outside investors, those are all things that need to be thought about. And mission protection. If the owner has built this business and has a particular mission or a particular legacy that he or she wants to continue, then what are the options and what are the structures that would most likely protect the mission of the entity?
So for instance, an LLC, which is a creature of contract, if there's mission in that operating agreement, I've just come to learn that in a state like Washington, that agreement can be modified verbally or by the dealings between the parties. Not very strong protection. Versus a public benefit corporation or a cooperative where that purpose can be baked into the DNA at the charter level. Charters are relatively hard to change. So mission can be elevated or de-elevated depending on preferences in different entities. As Linda said, Washington is replete with options for cooperatives in addition to social purpose corporations, LLCs. We've identified 5 different options for forming a co-op. One is to be done under the general profit corporation law. That's the general kind of model business corporation statute. You can form a general purpose corporation, stock corporation, and structure it to operate on a cooperative basis. 2378 is your employee cooperative corporation law. And I'm not exactly sure how that functions in relation to the other co-op ones, but you can look up chapter and verse and consult your local attorneys. The Cooperative Association Act is in chapter 2386. Actually, sorry, this site should go up there. It's 2386. 2406 is your Nonprofit, Miscellaneous, and Mutual Corporation Act. And then lastly, you're the newest addition to the club. Only 8 states now have the limited co-op association law. This has not yet even been given a chapter and verse. It was just signed into law. It will probably go into effect in a couple months, July. Not bad. And the LCA is based on a model statute that Linda's mentor helped draft and write, and Linda helped get that passed in Colorado. We'll talk a little bit more about what this involves. The Limited Co-op Association is not a corporate statute. It's like an LLC statute, but it has all the guardrails and protections of a cooperative. I like to call it a cooperative LLC, or cooperative LLC in a box. And most notably, in relation to traditional co-op statutes, it allows for investors to have limited voting rights, and it allows for profit sharing of the co-op in a limited sense to investors as well. It makes them more financeable or capitalizable with all the same trappings of a co-op: one member, one vote, member control, et cetera.
The USDA has a website that you can go in their rural development cooperatives website, and they have a database of co-op laws for every state in the country. And you can take a look and see what kind of co-op laws they have there. Let me back up a little bit. They are attempting to compile co-op laws for every state. They don't have it for every state because they haven't found attorneys in every state that are willing to help them input into the database. But they're working on it.
And they generally only cover the basic co-op corporation law. For instance, in New York, there's a co-op corporation law, but there's also an employee cooperative corporation law. The employee cooperative corporation law is not in that database.
And California, I think, has 4 different co-op statutes. Colorado, we've got 2 or 3. So yeah, they're not all in there, but it gives you a start on where to look for more information.
We also like to refer to this as forum shopping. For more than a century, big companies have been forming in Delaware, not because Delaware is a beautiful place and they like to visit, but because it's the motherland of American corporate jurisprudence, and the Chancery Court there is believed to be sending canons of God when it comes to corporate law. Likewise, cooperatives can be formed anywhere, and both on the pros and cons side, we don't have model co-op statutes other than the limited co-op form. We probably have about 150 co-op laws around the country, which means that there are lots of different options, and a co-op operating can choose to incorporate somewhere else so long as it registers as a foreign business where it operates. It's an opportunity to shop the laws around and find the one that's best suited to your particular expression of the co-op form. I don't think you have to do that if you're operating in Washington. You've got plenty of options here. But if you're in Arizona or some of these other states, you have to. In some other cases, like New York, Massachusetts, we'll compare for clients and tell them you still ought to incorporate in Colorado. We can do that in New York, but it's a nightmare.
Yes.
Joe?
So you said earlier this presentation is, or thinking about CoOp should be about substance and not about entity form, substance over form. But it seems like the more options there are, the more brain space it takes up to think about the entity. It's kind of distracting. And so people kind of move towards thinking about form more than substance, I think, because they have this choice to make, this big choice. Like if you were to try to whittle it down and say, like, if you don't want to think about it, here's your one best option. Is there anything like that?
Yeah, well, so this again is geared for attorney and CPA considerations. I would say the decision about where to incorporate or under what statute is likely not a decision that we put in the hands of the client and say, go figure it out. That would be a distraction. I'd say it's our job to understand your priorities, considerations, requirements, and if we don't have that option in the state, then it's our job to find a place where we can do it. With that said, we like Colorado law because our statutes are general purpose. You can form any type of co-op under Colorado statutes. It appears that you can do that under at least 2386 and probably under 2406. If that's the case, then it's a pretty easy decision. But there's some states where you have to shop. There are other states where you might want to shop. But I think that's really part of the job of the professional to sort that out and come up with a recommendation, and here's why.
We have our favorites, but we like to give everybody the options, especially in a group like this where we're talking to people that give advice to potential clients about what those options might be.
The other thing to say about that is not just choosing between co-op statutes, but choosing between a co-op statute and an LLC. There are other considerations involving employment status that make that decision relatively easy. So just one case in point, for workers with undocumented status, forming as a cooperative corporation generally requires that those workers are W-2 employees or contractors. Most of the time, they're W-2 employees. To be eligible to work on a W-2 basis, you have to meet employment authorization verification. You have to supply documentation of your work authorization, fill out an I-9. If you're undocumented and you can't do that, it puts you in an impossible position as a W-2. And if this is, say, a domestic workers cooperative where the lion's share, all of the workers are undocumented, we will often come in and recommend an LLC co-op where the members are receiving K-1s as partners, not as W-2 wage-earning employees. So employment status is another consideration, and that will help us to narrow down the options. And there's now kind of a well-trodden way of creating an LLC co-op to insulate undocumented workers from the I-9 requirement. Oftentimes, folks looking to form a worker cooperative think that we're merging ownership and employment, and we no longer have to concern ourselves with employment matters, wage and hour rules, overtime, salary, wage, exempt, non-exempt, contractor, employee, and that really is a fool's errand. The employment relationship stands in addition to the ownership relationship. Worker cooperatives are adding a layer, a new relationship on top of the existing relationship of employment or contracting. We have clients that often mingle the contractor employees within the same workforce and have misclassification issues. So these are still things to consider after the entity is chosen, because you may not actually remove the employment considerations.
Department of Labor is still out there. They're not going away just because you're calling them owners.
We also, for worker cooperatives in particular, it's also important to be careful about how you structure governance functions. Governance functions are not clearly paid work or unpaid work, and it does involve a case-by-case kind of fact-based determination. So what we tell people is just be mindful that governance work needs to be carefully considered under the employment regulation.
As an example, if you require the worker owners to meet once a month after hours to discuss ownership issues, do hourly employees get paid for that time? Is it overtime? Those kind of things need to be talked about and discussed and determined beforehand.
Yeah, and you're talking about the financials, and guess what comes up? Our marketing plan and who's doing marketing, and you start to get into the daily details. And it's not to say that a specific conversation is going to ruin your approach, but it's the blending and kind of boundarylessness of those conversations that can create problems, and wage and hour claims ought to be avoided.
Is there a difference, like, in when considering statutes, if we, like 2378 specifically says that as an owner you are an employee and must follow all employee regulations? Is there a difference between that and one of the more loose statutes, where even if you don't structure in that they're employees, is it essentially the same?
You still have to do the analysis of whether they're an employee or not. Are they an independent contractor? If so, who has control over them? All those control issues when you're talking about independent contractors. Do they have other clients that they do business for? Or are they just, do they come into work from 9 to 5 every day and walks like a duck, talks like a duck, must be a duck, is probably an employee, no matter which statute that you choose.
And even if a statute says you must be an employee, the thing with employment that's complicated, the definition of employee is different under federal wage and hour law, state wage and hour law, IRS, workers' comp. There's at least seven different tests, and then the IRS has a different one for partner and employee. So there's 7 or 8 different ways of looking at the employment definition. This adds another layer of complication. So we just say be mindful. You don't have to solve it, but just be mindful that this is a consideration. The other set of considerations after you've chosen an entity is, to what extent will ownership be expressed as equity ownership, i.e. traditional investment ownership? I own X% of a company because I've put Y dollars into it. That's equity ownership. Or I have, a profit interest to accumulate, or I have options. Those are forms of equity ownership. Generally with employee ownership, we're talking about participatory ownership, which is ownership expressed as the right to participate in, co-govern, and earn a dividend based on my participation. That's still ownership, but this usually involves dismantling people's idea of ownership, which is I own X% of the company, that's my equity, and that means I can vote X% of the voting power and I get X% of the upside, and if this goes bust, I get X% of the dollars in the bank. Those three concepts are treated differently in participatory ownership, and different models give you different options. Co-op statutes actually generally don't allow for equity ownership. We talked about employment decision-making can be treated and structured differently from profit participation. Again, one member, one vote is a central pillar of a co-op statute, but LLCs and corporations generally don't vote that way. They vote by equity investment. Profit allocation, again, is going to be viewed differently in a co-op versus some of these other models. And then really importantly for the CPAs considering which entity you're advising, pass-through entities, partnerships, S-corps, generally are not really suitable for creating reserves to be used for working capital or growth capital. All of the profit in a pass-through flows through the business entity and is allocated to the shareholders, the owners. And if you're going to draw on working capital, it's coming from those equity accounts. Whereas subchapter T co-ops and corporations taxed as C corps, you can amass retained earnings. The business entity itself has its own equity account, and that's indivisible. It can't be parsed out to the shareholders. And that's important for companies that are looking to grow, looking to build up their balance sheet to go out for financing, or just have working capital requirements.
So what is a cooperative? You've mentioned it once or twice throughout this presentation. Owned and democratically managed by its employees. Profits and losses are distributed based on, usually in a co-op, profits and losses are based on hours worked. But you can do a formula where there's a combination of seniority, job description, hours worked. You can create and structure a profit and loss distribution system based on your particular company. Now, profits and losses are separate in a worker co-op from wages. Wages, bonuses, any of your regular compensation methods, 401k contributions, whatever, are separate from the profits and loss distribution calculations and analysis. So just keep that in the back of your head. Again, that separates out the employee part of a person versus the owner part of a person. And here we're talking about the owners. In a co-op, a person can be either a member or a patron. And the best example of that is in an agricultural co-op. You've got farmers that are the producers of the co-op. They are the voting members. They buy fertilizer and seed from the co-op. They go out and grow their produce and they sell it through the co-op. Then you have Mrs. Smith down the street. She buys gas from the co-op, or she buys tires, or she uses the co-op's hardware store. She is not a producer or a voting member, but she is a patron of the co-op. And in co-op subchapter T taxation, she is allowed to a portion of the proceeds of the profits based on her use and patronage of the co-op. The board of directors on an annual basis gets together and says, okay, we've got $100,000 in profits. We want $80,000 to go to our producer members, $20,000 to go to our patron members. And they can split it up that way. And it's usually on an annual basis, and it's usually something that depends on cash flow. The board works with their CPAs and their accountants and come up with a formula that works for them. The next slide shows some more basics about co-ops. There's very limited interest allowed usually in the statutes on investments in a co-op. However, if you are working with a different type of co-op, a limited cooperative association, you can have investments that are more market rate investments. Voting rights are usually limited to patron members or to investor members. Now, we have patron members here, meaning members that use the co-op. The whole definition of a co-op is the people that actually use it, the workers in this case. In a farm co-op, it would be the agricultural producers. They're the ones that use the services or the products of the co-op, or they provide the services or the products for the co-op. Those are called the patrons. Then you have investor members, and your new LCA statute allows investors to invest in a co-op. They're outside investors. They may or may not, they could also be inside investors. In other words, you could have a member who is also a patron, okay, who is also an investor. So you can do all kinds of combinations. And what this allows, and if you have investor members under the LCA statute, they can have limited voting rights. The users of the co-op, the patrons, the workers of the co-op, would have majority voting rights in any vote of the total membership. Now, I'm not talking about day-to-day operations. The investors don't have any say in day-to-day operations of the company. They're just investors. But if there's a vote of the entire membership, then the investors and the patrons all come together and say, okay, let's have a vote. And the investors could have some voting rights, but they don't have to. That's all set up in the beginning when you form the co-op, and you decide at that point in time whether or not to allow investors to have voting rights. Yes?
So are there just 3 different classes of membership, or can there be more or varied?
You can have many, many classes of membership. Well, I have one co-op, 9 classes of membership. So it totally, and it's like there's 5 patron classes and 4 investor classes of membership in this co-op. And they split out, and it's a co-op that's a purchasing co-op. So they split out the sales people and the wholesale people and the employees. These are all patron members, and then they have 4 different classes of investor members, depending on how much investment was made. Up to 100,000, it's in this class. 100 to 250,000 was. So yeah, you can have all different classes of membership in a co-op. Usually in a worker co-op, it's fairly basic. But I'll give you an example in a little bit about a multi-stakeholder co-op that has employees as one of the classes.
One of our clients is what's known as a platform co-op. It's an online platform. Its members include the founders, 2 people who founded this thing. They are their own member class. They are also members in the worker owner class. And then there's the user owners, the people who use the platform. So if you could imagine Uber as a truly democratic institution where the drivers were owners, the office tech folks were were owners. That's kind of what they've done here. And so our client has the founders, the workers, the users, and then a separate class for investors. It's just a whole other realm of possibility to create multi-stakeholder co-ops that include worker ownership. And there are all kinds of ways of slicing and dicing governance, too. And some of our co-ops will say we want the workers to have the dominant voting power. Others will say we want the user owners to have the dominant power. And there's a lot of flexibility there, but that's a whole new realm.
How does that operationalize, like in the governance part of it?
It's no doubt complicated. A lot of these are still fairly new within the last 4 years, so they haven't faced really significant votes. But one just amended its bylaws through a vote of the membership, and I think they had 80% of the total voting power approve it, so they had no problem getting the vote passed. But they're still relatively new.
Okay. Yes, members are definitely not liable for the debt of the co-op, similar to a limited liability company or an S Corp or a C Corp. As an owner, your liability for the debts of the co-op are limited to your equity investments. And we are going to go into more detail about how that equity is generated, partially through a membership or ownership fee or pricing, price for a share of membership stock, but there are other ways to increase your equity account in a co-op, and we will go through that briefly. But basically, one thing about co-ops, and if you've not worked with them before, although I think most in this group have, a co-op is formed for the benefit of the members, not for the benefit of investors. It's not meant as an investment vehicle. It's meant as an organization that provides goods or services to or for its members. And that's the main difference between a co-op and a limited liability company or an S corp.